New Zealand's crime debate splits along a durable fault line, whether to reduce offending by lifting visible enforcement and consequences now, or by attacking the deprivation, addiction, family violence and youth offending drivers upstream over a longer horizon. The regional research converges on 7 distinct national approaches that recur across Auckland, Wellington and Canterbury, clustering around 4 problems: victimisation, youth offending, family violence and organised/drug crime. The recurring lesson is that the sentencing and gang law tier ping-pongs with every change of government, while the parts that survive are either operational machinery that successors quietly inherit, hotspot policing, financial intelligence, or the integrated victim and treatment-facing service models that no party wants to be seen abolishing. Enforcement, deterrence and victim focus. Visible police presence and credible, swift consequences are the precondition for any crime reduction. Hire toward international officer-to-population benchmarks, concentrate patrol on the highest crime locations at the highest crime times, hotspot policing, intensively manage recidivists, and fast-track repeat violent offenders through the courts, so consequences are felt before prevention can take effect. Its flagship moves are: recruit additional sworn officers and deploy them to the highest crime districts to reach target officer-to-population ratios, evidence-based hotspot policing at the top crime locations with minimum patrol dosage during peak hours, recidivist/high-harm offender management with intensive supervision, plus fast-track courts and CCTV/environmental design hardening, mandatory minimum and 3-strike-style sentencing for serious repeat offending. The central tension, enforcement without addressing deprivation drivers, tends to displace and redistribute crime rather than cut it in aggregate, and heavier policing of Maori and Pacific communities deepens overrepresentation in the justice system. The deprivation crime correlation, decile 10 areas have 3-5x the victimization of decile 1, means a purely enforcement-led strategy fights the symptom, not the cause. This has been partly tried. Operational policing, officer surges, hotspot patrol, recidivist management, has been pursued by governments of both colours and is absorbed rather than abolished. This layer is durable. The hard sentencing tier is the textbook ping-pong. 3 strikes enacted 2010, Act, repealed 2022, Labour, reinstated 2025 with a manifestly unjust safety valve act. It churns on the electoral cycle, and a future centre-left government is likely to repeal or dilute it again. Its durability outlook is rated likely contested. Prevention, diversion and social investment. Crime is downstream of concentrated deprivation, family instability and school disengagement, so the most cost-effective lever is upstream. Place-based social investment in the highest crime suburbs, diversion of first and second offenders away from the justice system, and co-located health, housing and employment services. This produces larger long-run reductions than enforcement at lower fiscal cost. Its flagship moves are: place-based social investment in the highest deprivation suburbs, coordinating housing, employment, mental health and education, community-based diversion for first-time offenders, with police-to-program handoff and follow-up, co-locate mental health crisis services at police stations, and stand up integrated community safety hubs, alcohol management zones, and youth mentoring/alternative education pathways in high-assault areas. The central tension, prevention pays out over 10-20-year horizons, while political pressure after high-profile incidents demands visible enforcement now, so prevention budgets get raided. It also depends on cross-agency coordination, police, MSD, health, education, that routinely underperforms because of budget siloing and fragmented accountability, and the long lag makes effectiveness hard to measure and easy to defund. This has been partly tried. Diversion is long established and durable as routine police practice. Place-based social investment has been launched, rebranded and partially defunded repeatedly. The wider Wellbeing vs Targets framing cycled National 2011 to Labour 2018 to National 2024. The model rarely gets the sustained multi-year runway it needs before a change of government or a budget round resets it, so the structural deprivation metric it targets has not moved. Its durability outlook is rated likely contested. Restorative and diversionary youth justice. Young people are best kept in community settings through restorative Tikanga-based processes that repair harm and address care, education and family deficits. Residential placements are criminogenic and should be a last resort. Intensive community supervision, rangatahi courts, Kaupapa Maori providers and guaranteed employment/education pathways produce lower reoffending at lower cost. Its flagship moves are expand rangatahi/Maori-based youth courts and Kaupapa Maori youth justice providers to manage a higher share of Maori cases, lift police youth diversion rates and mandate school re-engagement plans for youth justice participants, cap community youth worker caseloads, and fund intensive community management as an alternative to residences. Couple diversion with guaranteed employment and leadership/training pathways. The central tension, restorative justice requires victim willingness to participate, which limits its reach for serious violent offending, and high diversion rates can be read by communities and the political right as insufficient accountability. Genuine cost savings only materialize if residential care is actually reduced rather than merely supplemented, and intensive community caseloads are expensive. This has been tried. New Zealand's FGC-based youth justice model, 1989, is internationally regarded and has been a durable bipartisan baseline for over 3 decades. Rangatahi courts and diversion have expanded under successive governments. The contested edge is the recent swing toward youth boot camp/military academy and tougher youth offender measures, 2024-25 coalition, which sits in tension with the restorative model and is owned by the right. Its durability outlook is rated likely durable. Youth accountability and consequences. Restorative approaches are valuable for minor offending, but insufficient for serious, repeat violent young offenders. Proportionate consequences protect victims and deter others without abandoning rehabilitation by extending youth court jurisdiction, adding accountability orders, strengthening victim notification rights, and, in its strongest form, lowering the age of criminal responsibility for serious violent offences. Its flagship moves are extend youth court jurisdiction to serious violent offences by 10-13-year-olds with mandatory accountability orders, serious offending accountability orders, electronic monitoring plus mandatory program attendance as a residence alternative, strengthen victim notification and impact statement rights throughout youth justice proceedings, create a serious repeat youth offender register accessible to schools and social services. The central tension, evidence on deterrence for under 14s is weak and incarceration effects on children are actively harmful, so expanding the formal justice footprint over children risks worse outcomes. A youth offending register risks labelling and stigma that close off legitimate pathways and increase rather than reduce reoffending. The intervention can be criminogenic. This has been partly tried. Lowering the age of criminal responsibility and a youth register have been repeatedly proposed, but not durably enacted. The 2024-25 coalition introduced young serious offender categories, tougher measures and military-style academies. Early youth boot camp pilots have shown the high reoffending results such programs historically produce. This sits against decades of evidence and the established FGC model, making it fragile and contested. Its durability outlook is rated likely reversed. Integrated family violence response. Family violence, a police call every 4 minutes nationally, needs a whole system response rather than fragmented agency handoffs. Co-located police, social workers and housing navigators, integrated safety response, safe and rapid housing for victims, perpetrator behaviour change programs, including Kaupapa Maori, and culturally led whanau and Pacific prevention. It blends a right-leaning perpetrator accountability emphasis with a left-leaning victim housing/wraparound emphasis. Its flagship moves are family violence co-responder units, police social worker, and full integrated safety response Te Aotearoa rollout across all districts. Expand emergency refuge and transitional safe housing supply with priority rehousing for victims with children. Mandate and fund perpetrator behaviour change programs, including Kaupapa Maori, as bail/sentence conditions, with electronic monitoring for repeat protection order breaches. Fund iwi and Pacific-led whanau-centred prevention and cultural accountability frameworks. The central tension, the internal trade-off is where the marginal dollar goes: victim-safe housing first versus perpetrator accountability first, with each camp arguing the other follows rather than substitutes. System-wide, spending is skewed to visible crisis response over prevention. Safe housing competes with other vulnerable groups for scarce stock. Co-responder models strain on real-time information sharing, and perpetrator programs have long waitlists and variable completion that defeat the deterrence intent. This has been partly tried. ISR was piloted from 2016 and Te Aotearoa launched in 2021 as a cross-government strategy. Both survived the 2023 change of government as the operating framework, though funding intensity and scope are contested. The model is real but unevenly resourced. Prevention remains underfunded relative to crisis response, so recurrence rates have proven sticky. No party has tried to abolish the integrated approach itself. Its durability outlook is rated likely durable. Organized crime suppression and financial disruption. Gangs are enterprises in a prohibited market, so disrupt the business, target financial flows and assets, anti-money laundering audits, proceeds of crime recovery, prosecute leadership, stand up cross-agency financial intelligence units, intercept precursors at the border, and use gang association legislation to constrain public recruitment and activity. Enforcement creates the conditions in which exit programs can work. Its flagship moves are cross-agency financial intelligence units, police IRD customs, targeting gang assets, property and laundering, proceeds of crime recovery and AML audits of cash-intensive businesses, increase border force/customs interception of drugs and precursors at airports and ports, gang association/insignia and consorting legislation to disrupt organizational capacity. The central tension: decades of supply-side drug enforcement have not reduced availability or price seizures are replaced by new supply chains rapidly, so suppression alone does not shrink the market it targets. The prohibition rents constraint. Gang association laws raise civil liberties concerns, risk criminalizing association rather than proven offending, and fall disproportionately on Maori. Displacement to less scrutinized channels and jurisdictions is a recurring failure mode. This has been tried. Financial disruption and proceeds of crime machinery is long-running and broadly accepted across governments. It is durable operational capability. The contested tier is gang association legislation. The 2024 gang patch ban and dispersal/consorting powers, which is right-owned, legally and rights-challenged, and the kind of measure a future centre-left government may narrow or repeal. Supply enforcement has not moved the meth availability metric despite sustained effort. Its durability outlook is rated likely contested. Drug harm reduction, treatment and gang exit. Organised crime is sustained by drug prohibition and deprivation, and enforcement cannot disrupt an industry with this demand and margin. Treat drug use as a health issue, expand residential and community treatment, opioid substitution and drug checking, fund gang exit off-ramps with employment and housing, and review drug scheduling toward decriminalizing personal possession, shifting revenue away from organized crime while cutting justice costs. Its flagship moves are expand residential and community drug/addiction treatment capacity, prioritizing meth-dependent parents, drug checking services and waitlist-free opioid substitution therapy, funded gang exit programs with guaranteed employment and housing and multi-year case management, independent review of drug scheduling and decriminalization of personal use possession, redirecting enforcement to supply. The central tension: decriminalization faces strong national political opposition, the political constraint that drug reform has public resistance despite the evidence base, so the achievable harm reduction measures, treatment, naloxone, needle exchange, drug checking, do not touch the supply-side revenue base. Treatment capacity is gated by an addiction medicine workforce shortage, and gang exit is a multi-year, multiple-attempt process before members leave permanently. This has been partly tried. Harm reduction has a long durable lineage in NZ, needle exchange since 1987, drug checking made permanent in 2021, a health-based approach to personal possession via 2019 misuse of drugs amendment discretion, but the headline reform decriminalization/legalization has not been enacted. The 2020 cannabis referendum was narrowly defeated, and no government has moved on broader decriminalization. Treatment remains under capacity and gang exit funding is thin and intermittent. Its durability outlook is rated likely contested.